Good morning. Today we are going to start with the topic Right of Private Defense, Section 34 to Section 44 that relates with the right of private defense. Previously under IPC we were having Section 96 to 106. All those provisions now are there in 34 to 44. Two right of private defense are there. One is of private defense of body and private defense of property. Section 34 is just with one sentence, one line is there. Nothing is an offense when a person does it in exercise of right of private defense. Means section 34 is clearly stating that when a person does any act in the right of private defense, then that is not an offense. Okay. Now next is section 35, which states that a person is having right of private defense of body and of property. A person is having a right of private defense of his body and also others. Means he is having right of private defense to protect his own body and the body of any other person against any offense affecting human body. Means the right of private defense is not there just to protect our body, but it is also available to protect the body of others. This is the first right of private defense. The second is you are having a right of private defense of property also. Both movable and immovable property, you are having right of private defense of yourself and also others against any act which is an offense like theft, robbery, mischief, criminal trespass or attempt to theft, robbery, mischief or criminal trespass. So section 35 is telling that right of private defense are of two types. First, right of private defense of body to protect your body or others' body from any offense which are against human body. Second is you are having a right of private defense of property, that is movable or immovable, to protect your property or others' property from any offense which are theft, robbery, mischief, criminal trespass or attempt for this theft, mischief, robbery and criminal trespass. So this is section 35 stating about two types of right of private defense. Now what section, next section, that is 36 section, is telling right of private defense against an act of a person who is unsound mind or intoxicated person or who is acting under misconception of fact. See, in the previous provisions what we have seen, that if a person is involuntary drunk and if he does any act, then that is not an offense. Similarly, if a person is unsound mind and if he is doing something, it is not an offense. Now what has happened? The assailant, the attacker, the person who is attacking you, he is unsound or he is acting under misconception of fact or he is intoxicated. Therefore, if they do something against you, they will be exempted because nothing is an offense done by an unsound mind person and all. But they are going to cause hurt to you. So section 36 is telling you that you are having right of private defense against these people also. See what section 36 is telling. When an act which would otherwise be a certain offense is not an offense because of immaturity of understanding, that is a child, reason of youth, the unsoundness of mind, intoxication of a person or by reason of misconception of fact. Only because these things are there, it is not an offense on the part of that person. Every person has the same right of private defense against that act which it would have if the act were the offense. Means the attacker is either a young person, he is lacking maturity of understanding, he is intoxicated, he is unsound, he is working under misconception of fact. They may be exempted because of the previous provisions, but as they are attacking you, you are having right of private defense against those people. That is mentioned in section 36. Now section 37, that is restriction to the right of private defense. Acts against which there is no right of private defense. Now these are the restrictions on your right of private defense. Right of private, you are not having a right of private defense against a public servant who is acting under the color of his office. So you are not having a right of private defense against him because he is acting in good faith under color of office, within his powers. So you are not having any right of private defense against that public servant. A public servant is coming, showing you the arrest warrant. He is going to catch you now and take you to the police station. You have to go with him. You cannot assault him. You are not having any right of private defense. Or you are not having right of private defense against a person who is acting under the direction of the concerned public servant. This is the second restriction. And the third restriction is if you are having time to recourse to contact the officers, the law officers, to take their protection. At that time also you are not having right of private defense. Take example, somebody has threatened me today. So what I should do? I should immediately contact the police officers. And what that person has threatened me, that he is going to kill me 2 days afterwards. Means 2 days are there. I should not prepare and equip myself. I should approach the police officer and take their protection because time was available for me. But if I don't contact them and I equip myself and wait for the attacker to come and I attack him, then I am not coming under the right of private defense. This is the third restriction. In cases in which there is time to have recourse to the protection of the public authorities. And the next restriction is what? You are not allowed to use more force than the attacker. The assailant, whatever he is doing, you are having the same right, or you can extend and use same force. You are told to defend. You are not told to attack the person. Okay. Now these are the 4 restrictions on your right of private defense. We'll just revise. Section 37 is telling about restrictions. First is against an act which does not reasonably cause an apprehension of death or grievous hurt if it is done by a public servant acting in good faith under color of his office. Second is against an act which does not cause a reasonable apprehension of death or grievous hurt when it is being done under the direction of a public servant acting in good faith and under color of his office. This is second. The third is in cases in which there is time to have recourse to the protection of the public authorities. And the fourth is the right of private defense in no case extends to inflict more harm than it is necessary to inflict for the purpose of defense. This is the right of private defense, self-defense. You are being told to defend yourself, and for defending yourself you can use reasonable force, not more than that. If you do something more, then you will be liable. This is mentioned in section 37. 4 restrictions are there on the right of private defense. Okay. Now the next section is section 38, which is telling that when the right of private defense of body extends in causing death. Means 38 is telling you that when somebody is attacking you is causing an apprehension of death or grievous hurt and all, then you can cause the death of the other. Means when you can cause the death of the other, though you are causing the death of the other, you are coming within the right of private defense. See what we have seen under section 37, that you are being told to use force, cause harm, but it should not be more than the attacker. You are allowed to use reasonable force for defending, not more than that. But section 38 is telling that you can cause the death of the other. Means you are having right of private defense of body, and in that you can cause the death of the assailant, and though you cause the death of the assailant, it will not be called as a murder. You will be within the right of private defense and you will not be liable. You are coming under the self-defense only. Now when there are certain circumstances, like the assailant, whatever he has done, that is an assault, which may reasonably cause an apprehension that death will be the consequences. Second is where grievous hurt will be the consequences. Means the attacker, the assailant, is causing an apprehension in your mind that you will die, death will be caused, grievous hurt will be caused. In that case, you can cause the death of the other, death of the assailant. Such a type of circumstances are mentioned. First is apprehension of death. The second is apprehension of grievous hurt. Third is intention of committing rape. Fourth is gratifying unnatural lust. Fifth is kidnapping or abduction. Sixth is an assault with an intention of wrongfully confining a person under such a circumstances that he apprehends that he will not be in a position to have a recourse to contact somebody or to contact public authorities for his release. And the last is what? An act of throwing acid or attempting to throw or administer acid. Means apprehension of acid attack or actual acid attack. In that case also death can be caused. Means in these circumstances, 7 circumstances, the concerned person will come under the right of private defense though he causes the death of the other. We'll just revise. One is apprehension of death. Second is apprehension of grievous hurt. Third is rape. Fourth is gratifying unnatural lust. Fifth is kidnapping or abduction. Sixth is wrongfully confining a person in such a place from where he cannot contact the public authorities for release. That is sixth. And the seventh is acid attack or apprehension of acid attack. In that case also you can cause the death of the other and you can come under the right of private defense. Okay, bye bye. Further provisions we will see in the next video. See you.